about helping people. I'm passionate about
violating people's civil rights. Apparently, this is what this country has become. This is what this country. You guys are like addicted to IDs, and you don't even know the law.
I am here to do my job.
You're here to get my ID. That's all you want.
I need your identification to complete this process.
It's like crack to you guys.
Astronauts reported feels good. T-minus 5 seconds. 4, 3, 2, 1.
Bucking the system with the BullZDeep channel.
Hello, and welcome back. As promised, I'm keeping everyone updated with the events as they unfold. I just got the go-ahead from my attorney to share the demand letter on here. I changed the color of the paper to blue, to make it a little easier on the eyes. I also have a quick favor to ask, if you wouldn't mind. I just started another channel that I would like to get monetized for my son and his growing family. He's 24 and made me a grandfather twice over on September 2nd. Please head on over to @FreedomWatch99 and subscribe. Thank you so much. For those of you that found this, before the ID denial video, I will feature the original at the end of this video. This case involves a straightforward set of facts, all of which were captured on body-worn camera, which clearly demonstrate that on June 28, 2023, Officer Holbert and Sergeant Tyler of the Crossroads Police Department illegally prolonged the detention of Garth Beard due to their failure to understand the applicability of Texas Penal Code Section 38.02. This prolonged detention amounts to a violation of Mr. Beard's constitutional rights under the Fourth Amendment to the United States Constitution. Should the City of Crossroads choose not to resolve this matter now, suit will be filed pursuant to 42 U.S.C. Section 1983 in Federal District Court against each of these officers, as well as the City of Crossroads, for failing to train these officers on the laws they are responsible for enforcing, which led to prolonged detention of Mr. Beard. On June 28, 2023, Officer Holbert made contact with Mr. Beard's vehicle, which was parked in the Walmart parking lot, to investigate a dog being locked inside of a possibly unair-conditioned vehicle. Shortly after contact with this vehicle, Mr. Beard exited Walmart and approached his vehicle, as well as Officer Holbert. Officer Holbert explained the reason for her presence, as she was investigating possible animal cruelty. Due to the dog being inside of the parked car, Officer Holbert directed Mr. Beard to roll his windows down and step away from the vehicle. Mr. Beard was detained at this time. However, Officer Holbert quickly learned that the dog was fine. At this point, the reason for detention had ended, and Mr. Beard should have been permitted to leave. His prolonged detention was a violation of his Fourth Amendment rights. After arriving, Sergeant Tyler told Mr. Beard, "Here's the deal. As soon as you give your ID, and we're gone, you're gone." Sergeant Tyler told Mr. Beard that he was lawfully detained, and that Mr. Beard needed to identify himself. Mr. Beard calmly explained to the officers that he did not need to identify himself unless he was under arrest. Mr. Beard referenced the failure to identify statute and asked the officers to look it up because they were incorrect on what it stated. Eventually, Mr. Beard looked up the statute and read it to the officers, who continued to misapply the rules, resulting in an even longer detention. The officers finally walked away from Mr. Beard and decided to let him leave without identifying himself, which is exactly what the law requires, and exactly what Mr. Beard not only explained, but read to the officers, at 22 hours 34 minutes and 54 seconds timestamp. For body-worn camera, Officer Holbert told Mr. Beard she needed to identify him for documentation purposes. She knew at this point that Mr. Beard had not committed a crime. At that point, Mr. Beard should have been released. Sergeant Tyler even states during the interaction when releasing Mr. Beard that the animal is okay. However, the detention was prolonged until 23 hours 5 minutes and 21 seconds of the body-worn camera. When Sergeant Tyler finally told Mr. Beard he was free to go, this was 30 minutes of wrongful detention. Police Chief Sean Short sent Mr. Beard a letter explaining the shortcomings of Officer Holbert and Sergeant Tyler. Below are 3 paragraphs from that letter. You were sent an email on June 30th, notifying you this event had been reviewed after action review on the morning of June 29th with some shortcomings identified and addressed. Those shortcomings included employee knowledge regarding the application of 2 statutes, Texas PC 38.02, failure to identify, and Texas PC 42.092, cruelty to non-livestock animals, as well as the duration of your detention. First and most significantly, Texas PC 38.02, failure to identify was initially misinterpreted. This is a rarely used statute by the Crossroads Police Department, and in fact, during the 22 months of Crossroads Police Department has existed, to my knowledge, we have never arrested anyone for that offense. You were detained as a result of your leaving your animal locked in your vehicle on a summer evening. You were not arrested, handcuffed, or charged with failure to identify. That said, there was admittedly an unreasonably long discussion on the fail to identify statute. On the evening this occurred, there was a legitimate law enforcement purpose for our officers' presence. Investigation of a criminal violation, Texas PC 42.092, cruelty to non-livestock animals. Denton County Dispatch received the call at 9:14 p.m. Officer Holbert arrived at 9:24 p.m. When she arrived, she discovered your dog was confined in a parked, closed vehicle, with no one around. She observed the animal moving, but could determine little more. You arrived about 9:30 p.m., opened the door, and alleviated her concern that the animal was presently in danger. This indicates Officer Holbert knew that there was no concern about the dog's danger. After Mr. Beard opened the door for her to see the dog, thus going off this information, the prolonged detention would be 4 minutes longer. Notably, Chief Short also stated that there was admittedly an unreasonably long discussion on the failed to identify statute. This was because Texas PC 38.02 failure to identify was initially misinterpreted. This unreasonably long discussion was also an unreasonably prolonged detention and violation of Mr. Beard's constitutional rights. Interestingly, Chief Short blames the duration of the detention on Mr. Beard for being uncooperative. By not identifying himself, which Chief Short ultimately admits, Mr. Beard had no obligation to do. However, Chief Short states that the purpose for establishing your identity was to document the event. This is simply not what the law allows. Below is another paragraph from Chief Short's letter to Mr. Beard. The duration of your detention was partially attributable to your lack of cooperation. Officers' perception you absolutely have a right to disagree, not identify yourself, or ask questions about the detention. The purpose for establishing your identity was to document the events so that you could be released, and the incident could be reviewed and investigated later if appropriate. That said, officers should have worked more quickly through the animal cruelty investigation and not permitted themselves to be derailed by your assertion of your right to not identify yourself, which, as noted, was not required. I do appreciate your patiently standing outside your vehicle on such a hot evening while officers work through this. Texas Penal Code Section 38.02, failure to identify, states the following. A person commits an offense if he intentionally refuses to give his name, residence address, or date of birth to a peace officer who has lawfully arrested the person and requested the information. B. A person commits an offense if he intentionally gives a false or fictitious name, residence address, or date of birth to a peace officer who has 1. Lawfully arrested the person, 2. Lawfully detained the person, or 3. Requested the information from a person that the peace officer has good cause to believe is a witness to a criminal offense. Texas Penal Code 38.02 West. Here, Initially, Mr. Beard was lawfully detained, pursuant to an investigation into the call regarding his dog. However, once Mr. Beard opened the door to his vehicle, Officer Holbert's concerns were alleviated, and she knew no crime had been committed. Accordingly, when Mr. Beard was lawfully detained, he was not legally required to identify himself. Liability on this case is easy. The more complex question is, what are Mr. Beard's damages? Our law firm has resolved cases with similar facts for 5- and 6-figure amounts. While Mr. Beard did not suffer physical injuries, his rights were violated. The jury would award a damage amount for that violation. Then, after securing a favorable judgment at trial, as you are well aware, the court would order a separate award for attorney's fees, which, in a civil rights case of this nature, which would require numerous depositions, experts, and comprehensive briefing, would be substantial. The attorney's fees on this case would likely far exceed the jury award in this case. Additionally, the cost of defending this case will begin to add up the further litigation proceeds. All 3 of the officers who were present will need to be deposed. Training at the Crossroads Police Department will be thoroughly reviewed, as it appears there was a failure to train along with the policy of requiring all persons detained to identify themselves, in violation of the Constitution. This will set up a Monell claim that will require city administrators to become involved. Finally, should we lose at the district court level, we will most certainly appeal this case to the Fifth Circuit, requiring intensive briefing and argument in New Orleans. This case can be resolved without litigation based on the officer's clear liability. No chance of qualified immunity or summary judgment due to there being genuine disputes of material fact. The amount of discovery the Monell claim would require, and the inevitable award of attorney's fees in this case. Our authority to resolve this claim at this juncture is for $75,000, and in exchange for that amount, Mr. Beard will tender a full and final release of all claims. We believe that a jury verdict, an award of attorney's fees, will be far in excess of this demand. I look forward to speaking with you about this case. For those of you following along, thank you for your support. I will let everyone know if they agreed to settle, or if we are going to trial when I find out.